Uh, did we go on the record already?
Yes, Judge.
Okay, good. Okay, so just to confirm, A 1 through 8, B 1 and 2, C, D, and E through U are all admitted, correct?
Correct, Your Honor.
All right. What about for the defendant's exhibits?
Your Honor, we have objected to Defendant's Exhibit 4, 6, 11, and 12. So that leaves Defendant's Exhibits 1 and 2 are admitted, and 3. Defendant's Exhibit 5 is admitted, and then Defendant's Exhibits 7, 8, and 10, 9, and 10 we've agreed to as well.
All right, defendant's exhibits 1 through 3, 5, 7, 8, 9, and 10 are admitted. Okay, let's go ahead and call your first witness, Ms. Brandon.
Yes, Your Honor. BioT calls Terry Weber.
Okay. Ms. Weber, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
And do we have new counsel here that wasn't here yesterday?
Yes, Your Honor. In the room with Ms. Weber is the general counsel for BioT Medical. This is Mary Beth Conlon, excuse me, and she is physically in the room with Ms. Weber.
All right, Ms. Conlon, could you just state your name for the record?
Yes, Mary Beth Conlon as General Counsel for BioT Medical. Good afternoon.
Good afternoon. Let's proceed.
Okay, Ms. Weber, where do you currently work?
At BioT Medical in Irving, Texas.
And what is your position with BioT?
CEO.
How long have you held that position?
Since March of 2019.
Could you explain to the court what BioT's line of business entails?
We have two major pieces of business. Number one is hormone replacement for people entering middle age. And the second is nutraceuticals to help complement that hormonal treatment.
Okay, could you explain what nutraceuticals are?
Nutraceuticals could be used as supplements. They're over-the-counter supplements that are used to enhance health, wide variety of health to address certain deficiencies in the body, add minerals, vitamins. That's a supplement or a nutraceutical. The words are used interchangeably.
Okay. And does BioT consider its internal business operations to be confidential?
Oh, very much so. So we operate in a very competitive healthcare field. So what we do, both the training and all the products we provide, we consider confidential.
And what types of information does BioT consider confidential?
So as a typical commercial practice, we would say that what's confidential to us would be all of our product formulations, all of our customer lists, their emails, all their contact information, who their staff is, all of the sales materials related to our nearly 5,000 practitioners. We consider all of our pricing, any of our negotiation strategies, all of our vendor relationships, history of those vendor relationships, all of the sales history of each of the clinics and each of the practitioners, as well as each of the product lines, all of that related, each of the major departments, all of our finance costing numbers, as well as sales volume. These are all very valuable in our industry.
Okay. So what steps does BioT take to protect all of this information?
We use basically, like most corporations, pretty strong firewalls through our data. So we have data that's protected we keep everything in the cloud so as to not have any server type of issues. So we're cloud-based and all of those things are protected by passwords. We've got and different types of authentication. We issue a iPad to each of our employees, and that keeps our things confidential as well, so that don't allow them to use their private computers. We also have physical at the company. We have scanned, sophisticated scanning to enter the building. Only authorized people are allowed to enter the building. That's 24 hours a day, as well as all of our personnel dealings with all of our employees and all of our vendors are very protected by confidentiality agreements. People know what they're allowed to talk about and not talk about or disclose.
Now, when you mentioned that employees are not allowed to use their personal computers, what device does the company provide employees?
Depending on what part of the company, we provide iPads or Surfaces everyone's provided devices to that are attached to our company databases.
Okay. And a Surface is a type of laptop, is that correct?
Laptop, sorry.
Okay. Do you know the defendant, Michael Antonelli?
I do.
How do you know him?
I originally interviewed him when I first came to BioT and then offered him a position at BioT about a month after I started, a month or two.
And is Mr. Antonelli a licensed physician?
No, he is not.
Does he have any advanced degrees in functional and regenerative medicine?
No,
Does he have any advanced degrees in pharmacology?
no. I think he has a marketing degree.
Okay. So what is your understanding of his experience and background?
When I hired Michael, he was a salesperson for a company called Da Vinci Labs, who produced nutraceuticals for BioT.
Okay. What was Mr. Antonelli's role at Da Vinci Labs?
A salesperson.
Did he sell BPC 157? Did Da Vinci Labs sell BPC 157?
No.
Who does? Which supplier or manufacturer does sell BPC 157?
Tailor-Made Health.
When did Mr. Antonelli officially join BioT?
In April of 2019.
And what was his role at that time when you hired him?
We hired him as a regional salesperson in the Northeast region.
And during his onboarding, did BioT provide Mr. Antonelli with the policies that apply to employees?
Yes. So from day one, we provided all of our employee handbook, ethics, what's understood as an NDA, what information is confidential, not confidential. So we've supplied all that.
Okay. And Your Honor, I neglected to introduce Jonathan Matthews, who's our tech assistant, who's on the Zoom as well. I'm going to be asking him to pull up some exhibits as we go through this presentation.
No problem.
Okay. Jonathan, could you pull up Plaintiff's Exhibit E as in echo?
Your Honor, can you allow screen sharing?
Yeah, you have feedback, just FYI. Okay, go ahead. And I do have all the exhibits, just so you know, I do have all the exhibits here, I believe, or at least all the plaintiff's exhibits here.
Thank you. Very good, Your Honor. Ms. Weber, you have Plaintiff's Exhibit E is on the screen. Is this an example of the employee handbook that BioT provided Mr. Antonelli?
Yes.
And if you could flip to, Jonathan, if you could pull up Plaintiff's Exhibit Plaintiff's Exhibit F as in Frank. Okay. And what is this document?
That acknowledges that the employee has read everything and understands, and it governs, our relationship. So it's the acknowledgement page.
Okay. And is that Mr. Antonelli's signature on the page?
Yes.
Okay. And then can you pull up Plaintiff's Exhibit G as in good? And what is this document?
So this is an acknowledgement as well from 20 of the, so it's an NDA, I think. It's just one page here, employee net handbook. It looks like it's just the one page. Is this the one you wanted?
Yes, this the 2020 acknowledgement of the employee handbook as well?
Yes.
Yes. Now, and you can take this down, Jonathan, from the screen. Ms. Weber, did Mr. Antonelli sign any other documents in connection with his joining BioT?
There would be the usual ethics statements, and then a confidentiality NDA, which has a non-compete in it.
Objection, Your Honor. That assumes facts not in evidence.
World.
And Ms. Weber, did Mr. Antonelli sign the NDA, the 2019 NDA?
Yes.
Yes. And let's go ahead and pull up Plaintiff's Exhibit H. It's already in evidence. Now, this is the ethics policy that you were just referencing?
Yes.
Yes. And Mr. Matthews, if you could flip to the page that has the NDA. I think it's about a few pages in. There we go. Yeah. So is this the NDA you're referring to?
Yes.
And that same day, did Mr. Antonelli sign another document associated with this NDA?
Yes, there was an amendment to it.
Okay. And that amendment's reflected in Plaintiff's Exhibit I?
I believe so. Yes.
Is that the amendment on the screen?
Yes, it is.
Okay, let's leave the amendment on the screen for a moment. Is it common practice for BioT to have employees sign an NDA?
Yes.
And
Especially
why is
because it's really important. All kinds of information is very valuable out in the industry. So it's highly desirable. So we protect it very carefully. And so from the beginning of a relationship, we make it clear what is covered.
Did the NDA have a non-disclosure and confidentiality provisions?
Yes.
Yeah, and Mr. Matthews, could you pull back up Plaintiff's Exhibit H? And go to the confidentiality paragraphs 2 and 3. Scroll down. Ms. Weber, I believe you have a binder of these same documents in front of you, correct?
Yes. I can look at those, right?
Yeah, you can look at the paper copy if that's easier.
Okay.
Are paragraphs 2 and 3 the confidentiality and non-disclosure provisions you were talking about just a moment ago?
Yes.
So what was the purpose of the amendment to the NDA that Mr. Antonelli signed?
When Michael joined the company, he was not sure that was what he wanted to do, work in the hormones that the job entailed. So he said in case he wanted to go back to his former employer or to go back to that, he asked that we sign a amendment that he could go back to supplements if working on the hormonal part of our business didn't work out.
And just to be clear, did he initiate the request to amend the NDA?
Yes.
Okay, so let's go back to the amendment to the NDA, Plaintiff's Exhibit I, that page, if we could blow it up a little bit for the screen. And did the amendment, what paragraphs did the amendment alter to your understanding?
The non-compete for 2 years for supplements. So it would be.
Did the amendment alter any other provisions of the NDA?
No.
Okay. Did it alter the non-disclosure or confidentiality provisions of the NDA at all?
No.
Okay, thank you. You can take this down, Mr. Matthews. Now, was Mr. Antonelli promoted at any point in time from his sales manager position?
Yes, he asked us to go work in the nutraceutical part of our company as opposed to the hormonal part. So we promoted him to a position of business development with the nutraceutical line. So he then wasn't selling hormones anymore. He was working solely on nutraceuticals for our company.
And what year was that promotion?
So that promotion was in 2020.
Okay. And did the position involve an increase in Mr. Antonelli's roles and responsibilities with BioT?
A total change of his responsibilities. He no longer supervised. He did all focus on nutraceuticals, the development of nutraceuticals, the sales of nutraceuticals, and growing the nutraceutical business. That was his sole purpose, which was a whole pivot into that part of our business.
And as the Director of Business Development for BioT's Nutraceuticals, did Mr. Antonelli have access to BioT's confidential information?
Yes.
What types of information did he now have access to that he did not before?
What was our full line of nutraceuticals? What was the formulations? What was the pricing, all the vendor relationships? All of that would have been privy, as well as the sales of all of our nutraceuticals to individual doctors and clinics, and what the amount of those sales were, and access to all of our employees versus a small region. So he had full access across the company when it came to nutraceuticals.
So did BioT take any steps to address Mr. Antonelli's increased access to confidential information across the company?
Yes, we had to then change his confidentiality agreement to include supplements, because he was now going to be privy and developing core lines for us that we wanted to keep confidential. So it was just a given that he would have to come under that agreement.
Okay, if we could pull up plaintiff's exhibit A3 and scroll to the confidentiality. Is this the new agreement that we've blown up on the screen, the new 2020 confidentiality agreement?
Yes.
And what happened to the original NDA and amendment to the NDA that Mr. Antonelli previously signed?
This agreement
Objection, Your Honor,
superseded.
that calls for a legal conclusion on her part.
Overruled. You can answer.
Oh, I'm allowed. Okay, I'm sorry. I didn't know what that meant. No, we knew what it was, because it had to cover the supplement piece. So we knew that had to cover and change that original exemption.
Okay, so if we could turn to Mr. Matthews, if you could pull up paragraph 12 of the confidentiality agreement. Was it your understanding that this confidentiality agreement superseded the prior NDA and amendment?
Objection, calls for speculation, Your Honor.
That's what I believed.
Your Honor, I can rephrase.
Yeah, why don't you rephrase?
Okay. Ms. Weber, what was your understanding of what the 2020 confidentiality agreement did to the prior NDA and amendment?
That agreement then superseded, or was the agreement that governed the relationship.
And what is your understanding of how the confidentiality agreement protected BioT's confidential information?
What I understood and how we wrote it and had it was that all the information that was privy to for internal people at BioT would be protected under that. So that would be all of all the different dealings, all through supplements, all of our pricing, all of our sales history, all the finances, all the vendor relationships, all of that was covered under. We were very careful to make sure it was covered under confidentiality.
Okay, so let's scroll to the first page of the confidentiality agreement. And look at the paragraph for purposes of this agreement. Was this paragraph, did this paragraph define what you understood confidential information to be for BioT?
Yes, I think it's extensive.
And if we go down to paragraph 1, the number 1, this 2020 agreement, did it include a non-disclosure provision?
Yes.
Yeah. Did this 2020 agreement, if we can scroll down to paragraph number 4, did it include a non-solicitation
Yes, that was
provision?
important. Yes.
Why do you say that was important?
Well, I think it's very important that that the employee has agreed to what their restrictions are if they leave employment. So I think it's important that governs the relationship.
Did this, to your understanding, did this 2020 confidentiality agreement exclude nutraceuticals from the 2-year non-solicitation provision?
No, it's included.
All right, you can take this down, Mr. Matthews. Now,
Your Honor,
let's,
excuse me, may I make sure those are still available for my cross? I assume they will be, right.
Anything that they use will be available for your cross.
Thank you, Your Honor.
and let's discuss Mr. Antonelli's second promotion. When did that occur?
That occurred early in the year of 21.
And what was he promoted? What position was he promoted to?
Michael asked the company to give him a new title. He wanted the Chief Innovation title so that he could go and explore more types of innovation in nutraceuticals. It was totally for nutraceuticals, and it was to work with our vendors to provide new and unusual supplements, as well as to have a broader base of influence at the senior C-suite level. So it was a C-suite position.
Was the title Chief Innovation Officer?
Yes, for nutraceuticals.
And did the position involve a change in Mr. Antonelli's roles and responsibility then?
Yes, it did. He gave him access to the founder and to all the members of the C-suite, and privy to all of our strategic planning information, all of our plans. And then he had asked for a closer relationship to our practitioners. So we allowed him direct access to our major, or to any of our practitioners that he wanted.
All right, so can we pull up Plaintiff's Exhibit J, please? Is this the chief, who drafted this Chief Innovation Officer job description?
Michael drafted it with the help of the company.
And does this actually accurately describe what this new role that was created for him would entail?
It does.
And is there any, you mentioned that in this new role, he was going to work closely with the vendors and the suppliers and practitioners. Is there any supplier in particular that Mr. Antonelli became more directly involved?
Yes, he was very involved with TaylorMade, both health and compounding, 2 parts of that company.
Okay, so let's break that up a bit. You could take down this exhibit, Mr. Matthews. Can you tell the court what TaylorMade Health is?
Do you spell that too, just for the court reporter?
Sure, and that's Taylor, Tailor, and then separate word made, MADE,
Okay.
and then health, HEALTH. And for purposes going forward, we'll refer to TaylorMade Health as TMH or TaylorMade. Okay.
So TaylorMade, I met them, had 2 arms of the company, TaylorMade Health and TaylorMade Compounding. One created nutraceuticals and the other had more development of prescriptions and peptides, injectables. But they were both under the same CEO when I met them. They subsequently split.
Did BioT contract with either or both of those TaylorMade entities?
Yes, we did with both.
All right, let's pull up Plaintiff's Exhibit K. We can turn to that. And what is this document, Ms. Weber?
This is a supply agreement made with TaylorMade Health, who created our supplements. You can see it talks about they manufactured both at the same time here, but it basically talked about that they were going to be producing products for BioT, private label products.
And do you know, when was this agreement? When did BioT enter into this supply agreement with TaylorMade Health?
This agreement we signed in March of 2020.
Okay.
We've been speaking to them before about the development, but this was the legal agreement.
Okay. So if we flip to, I guess, the signature page, which is on the temporary injunction hearing page 146 of this agreement. Right there. Yeah, and could you expand that bottom part? Yeah, thank you, Mr. Matthews. And let's hear who signed this agreement.
I signed it for BioT, and Jeremy Delp, the CEO of TaylorMade Health and TaylorMade Compounding, signed it for them.
Okay. And what about TaylorMade Compounding? Did BioT also enter into an agreement with TaylorMade Compounding?
They were still combined at this point. So at this point, it would have been this one agreement. But this
Well,
one
let's-
talked about sleep products, talked about supplement products.
And did you have a separate marketing agreement with TaylorMade Compounding?
Yes, I believe so.
Could you pull up Plaintiff's Exhibit L?
Yes.
Is this the marketing agreement that TaylorMade Compounding entered in with BioT?
Yes, for peptides.
And by the way, could you tell the court what peptides and injectables are?
That's a different type of a product. Those are used for different health purposes and can be both prescription, and sometimes they're developed for over the counter, but peptides are a broad one. This was referring to a type or a narrower peptides that were injectables that our practitioners would then order for their patients, very patient specific. The supplements are ordered like you would do a private label to make a supplement sold over the counter.
Okay. And is the supplement private label process the process that BioT used with TaylorMade?
Yes.
And when was the marketing agreement entered into with TaylorMade?
In March 19th.
Okay. And if we can go to the signature page on page 6 of this document. And is that your signature there? You signed on behalf of BioT?
Let me see. Oh, there, yes. It's not in my thing here.
And Mr. Delk, CEO of TaylorMade Compounding, he signed on behalf of.
Signed as well.
Okay. Now, are you aware if Mr. Antonelli had worked with TaylorMade before his role at BioT?
No, I believe he met them while attending a show when he was an employee of BioT.
What position did Mr. Antonelli hold at BioT at the time that BioT entered the marketing and supply agreements in March 2020 with TaylorMade?
So at March 2020, he was just leaving his position in the regional sales and had asked for the position for nutraceuticals. So he was beginning into the nutraceutical business.
So once he got promoted into that nutraceutical business in March, April 2020, did Mr. Antonelli work with the TaylorMade entities in a more meaningful way?
Very meaningful, yes. A lot of his week was spent with them, working with them on our formulations and our sales plans.
Was there any changes or any modifications made to the 2020 confidentiality agreement with Mr. Antonelli in connection with his second promotion into the Chief Innovation Officer role?
No.
Why is that?
Because it encompassed what we needed to encompass, even with that promotion. There didn't need to be any deeper or change type of agreement.
And did BioT allow Mr. Antonelli access to the types of confidential information referenced in that 2020 confidentiality agreement?
Oh, absolutely. He had full access.
What types of additional information did he now have access to once he became Chief Innovation Officer?
He had all the access to a full, all of our doctors, whether they were domestic or Puerto Rico, Mexico, full access to them, their accounts, all their buying history, had full access to all the pricing, profitability, forecasts, formulations, business relationships. He had full access across our whole platform of information that we govern our business with.
Are you aware if Mr. Antonelli has made any statements in this litigation about his job functions at BioT?
Yes, I think he's talked to in deposition. I haven't seen the depositions, but I believe so.
Your Honor, at this time, I'd like to at least play a little bit, a portion of the deposition clip that's contained within Plaintiff's Exhibit V as in Victor.
Okay.
And Mr. Matthews, can you pull up this clip, deposition page lines 10, 6 through 10, 16 through 11, 1, and 9, 21 through 2011. If you could play that clip, please.
Okay.
As Director of Business Development for Nutraceuticals, did part of your duties include educating BioT's physicians on nutraceutical supplements?
That's right, it was.
And did you have any communication with BioT's vendors regarding nutraceutical supplements?
Your Honor, I'm having trouble hearing. I'm sorry.
I am too. Can
Yeah.
you turn that up?
I am.
And may I get the page number that this is starting on again?
Yes, this is Plaintiff's Exhibit V as in Victor. And it's deposition page 10, line 16 through page 11, line 1, and page 19, line 21 through page 20, line 11.
Okay. Go and proceed.
Mr. Matthews, could you play that clip and with the increased volume?
Sure, I'm going to try to increase the volume now.
Business Development for Nutraceuticals. Did part of your duties include educating BioT's physicians on nutraceutical supplements?
That's right, it was.
And did you have any communication with BioT's vendors regarding nutraceutical supplements?
I did, yes.
Did you communicate with them about the formulation of any of BioT's nutraceutical supplements?
Yes, I was part of the team that would communicate.
Mr. Ansell, you said there were several new breakthrough formulations that you worked on. What were those?
Yeah, so in 2021, my main objective was to improve profit margins for the company and also take the majority of the product lines, which were private labeled, generic formulas, and to create update opportunities that would give BioT exclusive innovation. We've had several meetings over this span of 2021 where I not only accomplished that, but none of it was approved and put into motion. So every single formulation upgrades to.
Can't hear this at all. I'm sorry.
Yeah. Mr. Matthews, your feedback is I don't know what's going on with the volume. Is there any way to
As
fix
Director
that?
of Business Development for
I have my volume
Okay.
maxed out on my end here, but I will attempt to try to boost it if I can here. Or it could be through the Zoom platform. It's extremely loud on my end. My apologies.
Ms. Weber, were you able to follow that, the page line deposition testimony in Plaintiff's Exhibit V as in Victor?
Yeah, and I was able to hear a little of that. So if you want to ask me.
Right, so were you able to hear Mr. Antonelli's description about his responsibilities involving BioT's formulations, product formulations?
Yes,
And did his statements and in his deposition describe some of the confidential information he was privy while at BioT?
yes. And then it was responsibility to innovate and to create exclusive formulations that BioT could sell under private label.
At some point, did
Your
you,
Honor, I have an optional completion of what little I could hear. I think there's a portion of that was not read to the court.
Barely hear it anyway. So go ahead. You can read it.
Okay. Question, page 9, line 10. And you see there in paragraph 3, it says, I was not privy to confidential information as it relates to supplements. I have not communicated or utilized any information that would be viewed as confidential since my departure from BioT employment. Answer, yes. Question. I want to understand a little bit better your job duties at BioT and understand the statement that you are not privy to confidential information as it relates to supplements. You were first hired as an area manager in April of 2019, correct? Answer, yes, that is correct. Question, then you were later moved to the position, moved to the position of Director of Business Development for nutraceuticals around the beginning of January 2020. Answer, I was awarded a title change, yes. And what was that title change? Director of Business Development. And was that Director of Business Development for nutraceuticals? That was part of it. And in paragraph 3 of your declaration, where you say, I'm not privy to confidential information as it relates to supplements, what are you referring to when you say supplements? Answer, nutritional supplements are defined, not by me, but defined by laws of natural compounds. So when you said supplements in your declaration, were you referring to nutraceuticals? Yes, nutritional supplements. I think that will conclude that. And I'm sorry, Judge, I apologize. I could not hear what he said.
I could hardly hear any of it either, to be honest.
Okay.
Also, Judge, the transcript will reflect that as well, because I couldn't write it.
Your Honor, we'd like to move to admit plaintiff's exhibit V as in Victor, which has the written portion of Mr. Antonelli's transcript. Now it has a section that we just played that you weren't able to hear. And you can see it in the, I don't know, Your Honor, do you have the actual deposition page highlighted, or do you have the clip report for plaintiff's exhibit V?
Let's see, you said you did pages 10 through 11 and 19 and 20. It looks like what I got was just a partial. Yeah, so it should have that.
It has, yeah. So I don't know if you're looking at the clip report portion, which is what we submitted yesterday as well. So it has on the first page, number 2, it has the 10 through 16 through 11 to 1. It has that section there. And then if you flip to page 4 of the clip report, item number 11 has pages 19, 21 to page 2011.
2011, I don't know what 2011 is.
20 line 11, I assume is what you means.
Yep.
Okay,
20 line 11. So
thank you.
So we'd like to at this point move to admit plaintiff's exhibit V as in Victor, since this is just, Mr. Antonelli's prior sworn testimony deposition in this case, and certain sections of it that, Mr. Pazzulli can offer the optional completeness as warranted.
Any objection?
I don't think this is the right way to do it, but I have no objection.
All right, exhibit V is admitted. V is in Victor. All right, let's proceed.
Okay, Ms. Weber, at some point, did you become aware that Mr. Antonelli gave notice that he would leave BioT?
Yes, in mid-July of 21,
And when was that?
July 15th, 2021.
And when was his last day at BioT?
He had a formal last day of employment, April 16th. And then he did a few lectures after that to fulfill obligations.
You said his last day was April 16th. Did you mean August?
August, I'm sorry,
Of 2021?
21.
Yeah, they both start with an A.
Did Mr. Antonelli have any role with BioT after August 13, 2021?
There were a few doctor dinners that he had set up with practitioners, and we didn't want to cancel those. So we had Michael finish those, and he was willing to do that.
Did BioT inform Mr. Antonelli that he was actually permitted to complete those dinners or trainings in August of 2021?
Yes, we did.
And let's pull up plaintiff's exhibit M as in Mike. And in August 2021 was the company, let's actually strike that. Let's scroll down to the next page, page 2 of this email chain that has Michael Antonelli and Gary Donovitz on it. Do you see that in the middle of the page?
I do.
And can you tell the court who Gary Donovitz is?
He's the founder of BioT.
I'd like you to highlight the last sentence of the email from Michael Antonelli to Gary Donovitz, where he says, please advise if you'd like me to continue with virtual meetings that are scheduled. You see that?
Yes.
And what was your understanding of the virtual meetings that were scheduled in August of 2021?
Those were doctor dinners that Michael had set up through his last months of employment that were where he met with doctors and then discussed their practices with them and their BioT nutraceutical business. It was for the purpose of growing their BioT business with those practitioners.
And then if we go to the first page of this email chain at the bottom, Mr. Donovitz responds, the very bottom of page 1, Mr. Donovitz responds to Mr. Antonelli and says, yes, please proceed. We will keep your non-compete you signed when you were promoted and pay you for scheduled engagements. Do you see where he writes that?
Yes.
And what was your understanding of what BioT's relationship with Mr. Antonelli as it related to the non-compete reference in that email?
This was to inform Michael that he was still under his non-compete, even though he chose to not go forward with an independent contractor agreement. It informed him, as we did multiple times, that his agreements were still in effect.
And is the agreement referenced there, the 2020 confidentiality agreement that we looked at earlier today as plaintiff's exhibit A3?
Like confidential and non-solicit.
Now, did BioT, well, after he left BioT, did you become aware of Mr. Antonelli's involvement in selling nutraceutical products?
Yes, I came into work one morning and received a call from a doctor who had told me that Michael had sent them a notice of a seminar he was giving, a webinar that he was giving on a product that we carried.
I object. This is hearsay. It's what some third party not here told her. It's just hearsay.
That's how I became aware.
Whoa.
Hold on.
I need to rule on that. That does seem to be hearsay. Response?
Your Honor, I'll rephrase the question.
Okay.
Mr. Matthews, can you pull down this exhibit? Ms. Weber, did you become aware of materials, a webinar in 2021 that involved Michael Antonelli?
Yes, I received a copy of a advertisement for a webinar advertising that Michael was lecturing on BPC 157.
No, that's still, excuse me. It's still hearsay. I object.
I think you have a copy of it.
Yeah.
Okay.
Ms. Weber,
let me just say this. When he objects, I'm the judge, so I rule on that. You don't rule on it, okay? So you make comments afterwards. It doesn't help. It just let me rule on that, okay?
Okay, I'm sorry.
That's okay.
Your Honor, may I respond?
That's your job. You can respond.
Yeah, thank you, Your Honor. Ms. Weber just simply stated that she received a document. She didn't actually discuss the document itself, so there is no hearsay. And frankly, this testimony is provided for the purposes of notice.
Okay, I'll overrule the objection at this point.
Now, please pull up plaintiff's exhibit N as in Nancy. Is this the promotional material that you were referring to, Ms. Weber?
It's still hearsay objection.
Your Honor,
Response.
Your Honor, Your Honor, I understand that plaintiff's exhibit N as in Nancy is already admitted into evidence, and so this witness can testify about it.
Let me double check.
I think that she is right. I think I did not object to that, Your Honor. So the document is in, but.
Yeah, so the objection's overruled. You can proceed.
Yep. Okay.
Ms. Weber, is this the promotional advertisement material you were just referring to?
No, this is a copy of the actual contents of the webinar. It wasn't
Okay,
the
well,
email I referred to earlier, which was the advertisement for it.
okay, so did you get a chance to see this, the contents of the webinar that's reflected here in plaintiff's exhibit N?
Yes,
And the title of this webinar, these slide decks, it says it's the power of BPC 157 Pro. Are you familiar with that product?
I'm familiar with that product.
Well, can you first tell the court what is BPC 157?
So BPC 157 is a over-the-counter nutraceutical that BioT purchases and private labels for from TaylorMade.
And what is, does BioT sell BPC 157 Pro that's depicted here on this webinar?
No, we sell BPC 157.
And you'd mentioned that BPC 157 is private label. What do you mean by that?
It carries a BioT. We were under contract for them to produce it for us and then put the BioT label as well as the marker of BPC 157.
Okay, so if you flip to your plaintiff's exhibit O on the marker, is this the label for BioT's BPC 157?
Yes, it is.
And when we go back to plaintiff's exhibit N with the webinar, what was your understanding of Michael Antonelli's role in this DNA Health, the power of BPC 157 Pro slide deck?
Objection. Again, that calls for speculation, Your Honor, and hearsay. How does she know?
Lay a foundation, how she would know.
Okay. Miss Weber, were you, did you become aware of this webinar that's reflected here in plaintiff's exhibit N?
Yes, I did.
Did you at any time view the materials that were reflected in plaintiff's exhibit N?
Yes, and I went to the website to see what DNA Health was.
And what did you discover when you went to the website to figure out what DNA Health was?
That it was a nutraceutical company that would be competing with BioT.
And who is associated with the company DNA Health?
Michael Antonelli.
And what was this webinar slide deck promoted on or reflected on the website when you checked it?
Just the webinar, not this content here,
Okay.
not the slide deck.
Was Mr. Antonelli himself involved in the actual webinar?
Yes.
And you mentioned earlier, and we looked at BioT, the image for BioT's BPC 157. When did BioT contract with TaylorMade to manufacture BPC 157?
In the spring of 2020, or I'm not sure what day we had them developed and then put a purchase order in for it between the months of like April and June.
And did the discussions with TaylorMade start months before that, before the product release actually took place?
Oh, it takes a long time to develop a product, yes.
Your Honor, with all due respect, I'm just not objecting to the leading, but when she's telling the witness what to say, I have to object.
Be careful about that.
Yes, Your Honor. Well, let's go ahead and just pull up Plaintiff's Exhibit X. This is an exhibit that's already been admitted into evidence, Your Honor.
Okay.
Okay. I'm sorry, I meant Plaintiff's Exhibit P. Is this P as in Paul?
Yes.
Yes, okay, thank you. And if we could just scroll to the bottom half of this email chain. This email chain that states it's from Ryan Smith to Terry Weber. Ms. Weber, do you see that? Do you see that portion of the email?
Yes, I do.
Do you recall receiving this email from Ryan Smith?
Yes, I do.
And can you tell the court what this email is about?
We were talking about the programs that we were launching with TaylorMade.
And who is Ryan Smith?
He was a vice president with TaylorMade.
And what are the core products being discussed in the email here, the different categories?
There were different peptides, male core 4, female core 4, and then supplements. There was a cosmetic cream that we then produced, and supplements for sleep, anxiety, hair, and then BPC 157 for gut.
All right, if we could scroll down to the second page and scroll down. Right. So what were the discussions with TaylorMade about these add-ons for supplements, hair, and gut about?
These were products that we would have that no one else would have, that we would have at BioT. They were not easily found. TaylorMade was one of the sole sources for these products. So we were very excited to commit and to develop a whole program of training for these products. So they became major pieces of our 2020 program in 2021 subsequently.
And so at the bottom, with regard to BPC 157, it states that it will be a BioT custom formulation as well. Did that occur?
Yes, I believe so. They felt they created these for us, and we were the major commercial seller. They had a small product line that was similar, as he refers to that, but he said that our formula would be different.
And if we scroll back to the first page of this, the email, back where he emailed you.
Yes.
Was Michael Antonelli involved in the discussions with TaylorMade Compounding in January 2020 as it relates to BPC 157 being formulated for BioT?
Yes, he was.
Yeah. And was he copied on this email?
Yes.
And well, why can you tell the court why BioT decided to sell BPC 157?
Because we had learned that there was great success with the product and that worked quite well, and that the small group of doctors that had been using it were really excited about it. So we added it to our line and then commercially put it through all of our providers, educated them, continued to educate our staff. So we really decided to get behind this product and promote it.
And do you know, in this email chain, Jeremy Delk, who you've already mentioned earlier today, and Ryan Smith, do you know if they are still affiliated with TaylorMade?
Yes, they're still affiliated with TaylorMade Health, though it's subsequently come under some different corporate names.
Did TaylorMade have access to BioT's revenue and sales that relate to BioT products?
Yes, we give them forecasts. It's part of our contracts with our vendors to make sure they can meet our supply needs. So we put forecasts out. They have the history of the sales, and then we forecast out rolling 12 months ahead what's going to be our use and need. And then the price and all the other confidential information that helps a vendor supply us.
Okay, so let's pull up Plaintiff's Exhibit K. Let's put the TaylorMade Health Supply Agreement back on the screen, or flip in your binder, and let's look at paragraph 8.2, please. Are you there, Ms. Weber?
Yes,
And is this section 8.2 regarding forecast what you were just describing as far as what you provide to your vendor?
yes,
And do you believe that the sales forecasting and revenue information that you forecasted to TaylorMade, did you believe it was going to be confidential?
yes. It's actually confidential under their agreement.
Okay, so let's turn to paragraph 12 of the agreement and highlight 12 and 12.1. Is this what you're referring to when you say it's actually confidential
Yes.
under the agreement? And why do you consider your revenue and sales information related to BPC 157 to be confidential?
Well, if a competitor knew about it, they would be able to then, do forecasts. They could find the largest users and target the largest users. So these things are really important. This buying patterns, and our plans on that are very important. What we're going to spend on sales and marketing, et cetera.
Has Mr. Antonelli admitted to soliciting any of BioT's customers to sell DNA Health's BPC 157 Pro to them?
Yes, I believe he did in the deposition.
And Your Honor, I want to highlight additional deposition testimony that's relevant to this particular testimony. We'll try the video clip. I'd like to ask.
I don't have any faith in that. So what is? It's Exhibit B.
Right.
What pages?
All right, so this is going to be actually Plaintiff's Exhibit W. This is
Okay.
the corporate testimony, and it's
Okay.
going to be page 18, lines 10 to 13.
Okay.
Your Honor, do you want me to actually read that into the transcript, or just highlighting it for the record since the exhibit is sent?
Yeah, you don't need to do that.
Okay, and then page 19, lines 9 through 20. Page 19, line 9 through page 20, line 8. Sorry
Okay.
about that. Okay. And then page 20, line 14 through page 21, line 5.
Give me a second. I got to read these.
Sure. Sorry about that, Your Honor. Tell me when you're ready.
Your Honor, rather than rereading them, there are places that she has not designated that I'm designating. So I just ask you to read the whole thing. That way I don't have to come back and ask you to read it a second time.
So you're everything that's not designated between each of these clips, you're designated.
Yep.
Okay. So
Yes, Your Honor. Excuse me. I'm sorry for saying yep.
Okay. Is that as far as you want me to go? 22, line 6.
No, and then, Your Honor, actually it was then page 36, line 11 through line 14, 36 lines 11 through line 14.
Okay.
And then I have just one more, Your Honor.
Okay.
Page 42, line 5 through line 18.
So these are the doctors that I guess he did business with that were, he says he removed from their list.
Yeah, these are doctors that he sent solicitations to, that he admits were BioT customers who he says that he later removed from a list after he was notified.
Okay,
At this time, Your Honor, I move to admit plaintiff's exhibit W.
any
This is
objection?
No, with the only condition on it that I'd be allowed to optionally complete. It was moving faster than I could read.
That's fine.
Thank you.
Let's proceed.
Ms. Weber, did Mr. Antonelli have access to confidential information after he left BioT?
Yes, I became aware that he had, after he left BioT and hadn't returned his computer, which we repeatedly asked for, that he had downloaded vast amounts of information that was confidential from our files.
I object.
And how did you?
Excuse me, hearsay. That's just pure hearsay. I
I've seen the
subsequently,
list.
Vote,
Ms.
response.
Your Honor, the testimony is already in evidence in the form of affidavit testimony, and Ms. Weber is simply testifying about how she became aware of it.
Overruled.
And how did you become aware of this information?
I was given the list of information that was downloaded and then asked to look at it. So I reviewed the files of what was downloaded. So I know exactly, because these are our files.
All right, so let's pull up plaintiff's exhibit D as in dog. Your Honor, this is already admitted into evidence. This is the affidavit of Jason Sue. Oh, actually, this is not admitted. I'm sorry. Can you please, this is not admitted, Your Honor. I would like to move to admit the affidavit testimony of Jason Sue. This is the one I was presenting yesterday, where he described the forensic analysis that was conducted. I believe a defendant's objection is really on, I'm not quite sure I fully understand their basis for the objection, but Mr. Sue has the qualifications to testify about what he did to conduct the forensic analysis and imaging of Antonelli's computer. And he testifies to the steps that he took, the processes he conducted, and the materials.
So
that
let
he
me find out what
discovered.
the objection is. What's the objection, Mr. Pizzoli?
he shows no qualifications to conduct any such of a forensic examination. The fact that he's of sound mind and claims to be capable of making an affidavit and serves as a client technology solutions architect, whatever that means, doesn't tell us what his qualifications are. It's a clear Robinson objection. He's not qualified, doesn't render any qualifications in the affidavit to permit him to render any kind of an opinion on what's inside.
Miss Brandon, where is his qualifications listed? You said they were listed.
The qualifications listed, look at paragraphs 2 and paragraphs 3. We're not offering him as an expert, providing expert testimony. This is a member of an IT technical solutions firm, and he's providing a summary of what the steps that were taken to conduct forensic analysis.
Response
Now,
to that.
Mr.
Sure, Your Honor. The fact that he works there, he could be the one running the shredder. That doesn't mean he's qualified. It doesn't state what his undergraduate degree is, what his graduate degree is, what his qualifications are to be able to extract data from a laptop, what the type of the laptop was, how he performed that. None of that's here. It's just, here's what I found, and I worked for Reed Smith, and therefore I should be allowed to say whatever I want to say, and that's not how it works.
I have to agree with Mr. Pizzoli on this. I'm going to go ahead and sustain the objection.
Now, Ms. Weber, were you aware, what types of information and files did you become aware that Mr. Antonelli accessed on his computer?
Objection, may I ask, Your Honor, how she became aware?
Yeah, lay a foundation.
At some point, Ms. Weber, did you request a forensic analysis to be conducted on Mr. Antonelli's computer?
Yes, I did.
Did you receive results from that forensic analysis of Mr. Antonelli's computer?
I did.
Objection, Your Honor. That calls for her to testify about the document you just sustained objection to.
Sustained.
At Ms. Weber, did you become aware that Mr. Antonelli had accessed documents that reflected a customer list from BioT Systems?
Objection, same objection, calls for hearsay. And
Your Honor, this is she's testifying about what she became aware of. Frankly, it should go to the weight, not the admissibility of the testimony. She's already stated that she actually requested a forensic analysis to be conducted, and she can then testify as to what she saw from the results of that analysis.
no, she can't, Judge. I'm sorry. Excuse me, Your
Yeah.
Honor. You're ruling, not me.
Sustained. Objection is sustained.
Now, Miss Weber, did Mr. Antonelli disclose to you at any point in time that he had maintained any of the confidential information that belonged to BioT?
Did he disclose to me? He discussed things with me during his employment that would show that he had access to those and was using the information.
Objection, non-responsive.
Yeah, sustained.
Yeah. Miss Weber, did Mr. Antonelli disclose to you before he left BioT that he was going to maintain confidential information that belonged to BioT?
That he was going to keep it confidential, is that what you're saying? Yes.
Yes, yes. And did Mr. Antonelli disclose to you that he had access to BioT's financials and revenue information after he left BioT?
I did not have that discussion with him.
Is Mr. Antonelli's company, DNA Health, selling other products that are similar to BioT's products?
Yes.
And what products are you aware of that he's selling that are similar to BioT's products?
Similar product to our Serene product, similar to ADK, an Omega product, and I think also a Cosmos, well, I'm not sure on that, but those are the ones I'm sure of.
All right, let's pull up Plaintiff's Exhibit Q, as in Queen.
Be back.
Ms. Brandon, can you have her repeat the that list I got after the Omega product?
Yes, Ms. Weber, what were the similar products that you're aware of that Mr. Antonelli and DNA Health are selling?
So our products' names were Serene,
Spell that.
SERENE, which
Okay.
is similar to his Calm, and then ADK, similar to the Defend. I think I didn't just mention BPC 157, but BPC 157 is one of his core products. And we sell a Omega product, as well as we have a product called Senolytic Complex, which is very similar to his Quercetin 500.
And let's focus on the Serene product, the BioT Serene product, SERENE. You stated that which DNA Health product is Serene similar to?
Calm, CALM.
And when did BioT launch the Serene product line?
In the spring, summer of 2020.
And who is BioT's manufacturer for the Serene product line?
Tailor-made health.
Is the Serene product line covered in the March 2020 supply agreement with Tailor Made Health?
Yes.
All right, let's pull up the plaintiff's exhibit K, the Tailor Made Health supply agreement. Let's go to paragraph 3.2. Okay. And what is the product listed in paragraph 3.2 that covers the Serene product line?
The DHH-B.
Is that B as in boy?
Yes, describes the active ingredient.
Was Mr. Antonelli involved in BioT's work related to the development of the Serene product line for BioT?
Yes, and they were product formulas that were only owned by Tailor Made. So we believe this was an exclusive agreement with us.
And so let's pull up plaintiff's exhibit R, as in Robert. Your Honor, this exhibit's already been admitted into evidence. Okay. And Ms. Weber, let's say at the top of this email has your name. It's an email from someone at BioT, Laura Jacks, to you and a host of other people. Do you see that?
Yes.
At the top. All right, well, I actually want to start at the back of the email, page 2. Let's start at the portion that's.
There's somebody named Jason Husui or Husu that's trying to enter. Is he in this case?
Yeah, yes, Your Honor, if we could, Jason Sue is the affiant for plaintiff's exhibit.
The one we didn't admit.
D. Right, correct. And he's joining to prove up the testimony. And we can suspend Miss Weber, or we can call him next as Your Honor may prefer, but we did ask him to join to provide this qualification.
I just want to point out we have about another hour left on this. I was told that you only had an hour with this witness, and so you need to get this done if you want to try to finish this today.
Yes, Your Honor.
If there's a total of an hour left, I've got way more than an hour on my case in chief, just to let the court know. So, and I'm not trying to pour water on anybody's parade, but I do have a case I need to put on.
Let's get this done.
Miss Weber, was Mr. Antonelli involved in the discussions concerning the Serene product line in plaintiff's exhibit R?
Yes.
Can you explain what his role was?
So he had a full role with the nutraceuticals. He worked on the development of the products, the vendor relationships, the timing, the marketing, the sales materials, the educational materials, all of the supply chain pieces. So that was his job description. He was the one employee we had that was totally focused on nutraceuticals.
Okay. All right. So then if we go back to the front page of this email, the top line from Laura Jacks, when she states there's a 6-week lead time for the tailor-made supplements, BioT Deep Sleep and BioT Serene. With this timeline, we should have product available by June 26, 2020. Do you see that?
Yes.
Is that the timeline that BioT followed as summarized by Mr. Antonelli in this email?
Yes.
So based on this email, was Mr. Antonelli aware of the specific product lines that BioT decided to keep investing and grow?
Yes, he worked deeply on it.
Was Mr. Antonelli aware of the sales and revenue targets for these product lines?
Yes, he helped develop them.
And Your Honor, at this time, I'd like to reference the court to Plaintiff's Exhibit W, Mr. Antonelli's corporate rep deposition at lines 28, page 28, sorry, lines 11 to 23, and it's short enough that I would actually like to just go ahead and read it into the record, Your Honor.
Okay.
And starting on page 28, starting on line 11, question, paragraph 14 reflects the seller's financial statements. Has DNA Health received a copy of the seller's financial statements? Answer, the financials I received were as it relates to BPC 157. Question, so the financials related to BPC 157 you received from TaylorMade would have been what exactly? Answer, anyone who's ever purchased, its profit and loss statements, any financials, relating to the sales of anybody. Question, including BioT? Answer, they were part of that financial statement. Yes.
Okay, go ahead.
So, Ms. Weber, was Mr. Antonelli aware of the formulations and ingredients in the BioT product lines?
Yes.
Do you know which vendors DNA Health uses for its products?
I've become aware since this deposition that it's tailor-made, and I would
And by
believe
the-
it's tailor-made. Yeah.
Do you know when DNA Health was formed?
In May of 2021.
And in May of 2021, did Mr. Antonelli disclose to you that he had formed DNA Health while he was still employed with BioT?
No.
Now, Ms. Weber, what are you asking this court to do today?
I would like the court to uphold the agreements we have with Michael Antonelli, both on the non-disclosure and the non-solicitation. These are competing products and they're very important to us. And so are the lists of all our doctors and all of that information.
And how do you know that BioT's confidential information is being used by DNA Health?
I've seen part of this deposition that talks about our financial numbers that were used for some type of a forecast for or an agreement for Michael. So that was evidence that's being used, as well as the physicians that tell me they're getting solicitations.
And the agreement that you just referenced about forecasting, was that the excerpt of the asset purchase agreement?
Yes.
Okay, let's pull up plaintiff's exhibit T as in Tom. Your Honor, this is already in evidence, this document. What is your understanding of what plaintiff's exhibit T as in Tom is, Ms. Weber?
It says it's an asset purchase agreement between TaylorMade and Michael Antonelli that was entered into when he was an employee, a C-suite level employee, who was responsible for the sales of BPC 157. This literally excerpts agreement talking about a financial relationship between Michael Antonelli and TaylorMade, who's our vendor, and then talks about BioT sales, BioT physicians, and uses it as a basis of part of their relationship.
Have you been able to see this entire document that's referenced as an asset purchase agreement?
No, I haven't.
And why do you believe you need to see the entire document?
Section called for speculation.
I believe
Ms. Weber, you've got to let the court rule on the objection. Your Honor, may I
You need to lay a
respond?
foundation for that, why she would feels like she needs to.
Miss Weber, when you saw this information, this paragraph 14 about BioT sales in an asset agreement between Antonelli and TaylorMade and DNA Health, what did that mean to you?
it means that one of my primary products for sale is being targeted by a former employee using my lists and colluding with my vendor. It absolutely was like nothing I've seen in my career. It was appalling. It stopped me in my tracks.
Objection.
And
Your Honor, I just object. That's nothing but argumentative and it's not substantive.
Overruled.
are you aware of any statements Mr. Antonelli has made in or submitted to this court concerning what his rights are related to BPC 157?
Yes, in his deposition, he referred to the fact that he could stop the sales to BioT of this product.
All right, Your Honor, I'd actually like to refer to that excerpt from the deposition.
Okay. What
The
exhibit
direct
number is it?
report. It is plaintiff's exhibit V as in Victor. And it is page 62, line 5. So 62, line 5 through 63, line 22.
Okay.
I'm sorry, that was line 5 to when?
62, page 62, line 5 through page 63, line 22.
It's a little confusing to me what this means, but okay, go ahead.
What was your understand? Did Mr. Antonelli also, are you aware of a declaration that Mr. Antonelli submitted to this court as well?
Yes.
And what was your understanding? Well, let's go ahead and pull up plaintiff's exhibit U. We'll come back to this purchase agreement. Let's go ahead and pull up plaintiff's exhibit U, which is already admitted. And highlight paragraph 5. In plaintiff's exhibit U, paragraph 5 states there that Mr. Antonelli states TaylorMade Health and BioT have an agreement wherein BioT purchased BPC 157 from TaylorMade. I own that product line and I have granted TaylorMade Health permission to continue to sell to BioT exclusively. I have purchased the exclusive right to distribute BPC 157 and its product line. I own the product line in and the right to distribute it. Do you see that?
Yes.
When BioT contracted with TaylorMade to manufacture BPC 157, did you have an understanding of whether or not DNA Health or Michael Antonelli owned that product line?
No, because it was early in, it was in 20 that we began that arrangement. 2020.
And when did Michael Antonelli, you go on, when did Michael, in paragraph 5 of plaintiff's exhibit U, let me direct you to the middle of that paragraph. He goes, when I left BioT, I started my own company, DNA Health, and purchased certain assets, which included, but are not limited to, the entire product line and the right to distribute BPC 157. Did you see that?
Yes.
What do you think about that statement?
This was a surprise to me, an absolute surprise. So it's very disturbing. It's a large piece of our business. Our practitioners are dependent on it. And this is a surprise. So I'm very concerned about the product line, the practitioners and the patients who buy it from them.
Did TaylorMade at any point inform BioT that it had entered into any agreement with Michael Antonelli concerning BPC 157?
No, I just became aware during this deposition.
And let's go back to plaintiff's exhibit, to the asset purchase agreement excerpt, plaintiff's exhibit T as in Tom. And this agreement between TaylorMade Health and Michael Antonelli and DNA Health,
Yes.
when you saw that it included BioT sales information, did BioT provide the sales information to TaylorMade Health and Michael Antonelli to enter into this agreement?
No,
Was BioT even aware that this agreement existed as of July of 2021 when it was signed?
no,
Was BioT aware that TaylorMade was potentially granting DNA Health and Michael Antonelli exclusive rights to BPC 157?
Objection, that's speculation.
Overruled.
You can answer.
so could you repeat it again?
I said, was BioT aware that that TaylorMade was potentially granting Mr. Antonelli and DNA Health exclusive rights to the BPC 157 raw products and product line?
No,
Before this litigation, were you aware that Mr. Antonelli was taking the position that he was granting permission for TaylorMade to continue to sell BPC 157 to BioT?
no,
Did TaylorMade provide BioT any notice of an assignment of rights or claims pursuant to the TaylorMade supply agreement as it relates to BPC 157?
no, our agreements are that you can't assign rights in our vendor agreements without permission. And I had no.
So have you seen this complete copy of this asset purchase agreement reflected in Plaintiff's Exhibit T, as in Tom?
No, I haven't.
And do you believe you need to see this agreement?
Objection, speculation.
I believe it would be important to understand.
Miss Weber, you have to allow the court to
Overruled.
rule on the objection.
You can answer.
I think this would be really important. This is an important product line. I have to explain to my practitioners what's going on. If this is an interruption, I would really have a problem with supply chain more than ever this year. So this would be a lot of patients and a lot of practitioners that would be impacted.
Why do you believe that BioT can ever fully recover from the conduct that DNA Health and Michael Antonelli have engaged in?
Objection, Your Honor. That's
Overruled.
speculation.
You can answer.
I'm very concerned. I've got a major vendor who makes 6 products, who's now making 4 competitive with a relationship I don't understand. I've got a violation of my contracts on 2 parts. I don't want to be in litigation. I want to discuss with this vendor what's going on, and I need to actually know what's going on to protect the patients and the practitioners. I don't know.
Did you at any time inform Mr. Antonelli about the potential harm disclosing confidential information could cause the company?
Michael is part of our C-suite where he knew how important it was to protect this information. It was a key part of his relationship with us, was how important this practitioner relationship is, how much we protect that, and how we intend to have it for the full term of that practitioner practicing medicine. So this is a very strong relationship that we protect and care about.
Okay. And just a few more questions, Ms. Weber. Let's go back to the BioT files. What's the file names within BioT's system where BioT houses information related to its practitioners and their sales data?
So that would be all of the Excel files that would include a Zoho database, which would include all of the individual practitioners and all their relationship and information. We have something called BioT Method, which lists every single transaction and all of the payment history. We have files which would be employee lists. We would have doctor dinner lists that would include all of the dinners and the people that attended those. We have refreshers, which would be all the docs that attend all of our training. We have files that have all kinds of proprietary established educational systems that we've paid for that would be related to work sessions, workbooks, outside sales modules and things that we've purchased. So we have extensive files, on our files that maintain all this information, keep it up to date.
Thank you. Thank you, Ms. Weber.
As a witness?
Yeah, pass the witness. Sorry.
Okay, thank you.
Ross?
Your Honor, yes. Ma'am, I have a few questions for you. TaylorMade is your supplier of BPC 157, correct?
Correct.
And TaylorMade has universally and consistently supplied you with all the BPC 157 you want, right?
Yes.
That TaylorMade has done an outstanding job of ensuring that you have gotten one BPC 157, correct?
They've supplied us, yes.
And they have supplied it at your request, and they've done it, right?
Yes.
Just so the judge knows, who owns TaylorMade?
I believe TaylorMade is owned by a group of financial people, including Jeremy Delk, and who has a position, and Ryan Smith. There's different TaylorMades. There's TaylorMade Health and TaylorMade Compounding, and they've subsequently split to other different types of entities, as was required by the DOJ.
Michael Antonelli owns TaylorMade, doesn't he?
I am not I've never heard that.
Okay, what did you think that asset purchase agreement was that you so desperately want? What do you think it's about?
Objection, objection, Your Honor.
Mr. Bazzuli,
This is-
okay. All right. Let's do this at this point.
No.
Let's go ahead and stop this temporary injunction right now. I'm going to order this entire asset purchase agreement based on that statement that you just made, Mr. Bazzuli, to be turned over to the plaintiff so they have an opportunity to fully prepare for this temporary injunction. That is the pretty shocking what you just said, Mr. Bazzuli.
I apologize to the court, and I don't want that to hurt my client.
Well, it's outrageous that you would make that argument, try to get her to speculate it, and then withhold the document. That is one of the more shocking things I've seen, Mr. Bazzuli. And so it's up to you, Ms. Brandon. I'm happy to have this delivered or allow you to come pick it up or however you want to do it. But Mr. Bazzuli, I cannot believe you just did what you did.
My apologies.
Ms. Brandon,
Your
what do you
Honor,
want to do?
Yeah, Your Honor, I will ask that we suspend this temporary injunction hearing. We want a copy of that full agreement. But Your Honor, we did file an amended petition this morning with an application for a temporary restraining order based on the additional information that the defendants have produced over the last 5 days, including this new revelation today. And we would ask to have an immediate TRO hearing to get a TRO or argue for a TRO to be put in place pending the full completion of a temporary injunction.
I can do the temporary injunction tomorrow if that helps. Because after these next couple of weeks, I'm worried with hopefully the pandemic clearing, I'm going to be in jury trial all the time. And so you want to get it done now. Can you do this tomorrow?
I'll do it tomorrow.
Well, Your Honor, we'd ask that the full agreement be produced like within an hour of this hearing. And any related documents as well. I mean,
I don't know what related documents are.
Okay.
I know what was produced. I'm pretty shocked by what's just happened, to be honest. And so, Mr. Bazzuli, I don't know if I want to have this. You could have somebody come pick up my version of it. I only have one copy, or we could have Mr. Bazzuli.
he can just email it to us. He can just email us a copy. The lawyers, he can email us a copy right now, a copy of the full unredacted copy of the agreement. I mean, he has it in his possession, and I think that's the fastest way to get a copy.
Your Honor, I would ask that that be for attorney's eyes only.
You've just asked this witness about that document and has asked her to speculate and just revealed that your client has apparently bought this entire vendor. I mean, I don't know how you can possibly try to argue that at this point after what you just asked her.
I thought it was common knowledge that he was the purchaser. That's the whole point, Your Honor, was I believe that, and I'll go back and look, but I believe that there is evidence in this case that it's been disclosed he was the purchaser. That I wouldn't have done it if I thought it was a secret, Your Honor. I would never do something like
Ms.
that.
Brandon, did you know that?
Your Honor, that it was all news to us. The only document that we've received 2 documents about Mr. Antonelli's relationship with TaylorMade and buying assets. His declaration, which we just read into the record, and that it's redacted paragraph 14. That's it. At no time, we deposed Mr. Antonelli. He didn't disclose this information during his deposition. We'll submit the entire deposition transcript in the corporate capacity, individual capacity. We have been spending weeks trying to get this information. He's never stated that he actually, quote, owns TaylorMade.
All right, I apologize. I can understand why the court's upset. I honestly believe that information.
To be honest, I'm not really upset. I'm just kind of shocked that you would have asked that, but I'm not upset. I'm just,
I thought she knew, Your Honor. I wouldn't just ambush her with that, with the document, holding the document back. I don't do that.
You basically are like, I'm going to withhold this document, but you guess what it says? I mean, I'm a little stunned. I'll just say that. But that being said, let's get that emailed over. Let's reconvene tomorrow at 9:30. It needs to be emailed within the next 15 minutes. Ms. Brandon, if you don't have it within the next 15 minutes, go ahead and contact Rhonda and we'll reconvene this Zoom and we'll start up. I do have a short trial tomorrow at 9:30. I don't think it's going to be very long, but we'll Rhonda go ahead. I don't know if Rhonda's on here. I'll tell Rhonda to go ahead and send you a link for tomorrow. But we'll take it from there, guys. Anything else?
No, I'll have it there in the next 15 minutes, and I will find where it was my understanding they had actual knowledge. I would never have asked that question like that. Judge, I've been doing this 45 years. I don't just do something stupid.
Well, I didn't know. Anyway, I'm not criticizing you. I'm just surprised.
You have a right to criticize me if you think that. And so okay. I'll try to fix it. Yeah,
all right, no worries. Let's just get it sent over, and then once you get this, we'll just kind of try to fix this. We're gonna, Ms. Brandon, it's up to you. I don't mind if I'm not opposed to having you ask her questions about it tomorrow morning to start, or we can let Mr. Bazzulli finish his cross and then you can ask questions. It's probably safer just let Mr. Bazzulli finish his questions and you can ask questions about the newly produced documents. And so, but we'll start this back up at 9:30. All right.
You got it. Thank you.
Yes, Your Honor.